Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now take a look at this. $300 million settlement deal is officially approved by the SEC, and today is going to be presented to us this week. It is going to be very historic. Please, gentlemen, take a look at it for yourself. At this time, Ripple Labs is waiting for a settlement arrangement that they have approved. Just recently, a tweet that was put out by Jen Nelson provided a hint that the SEC would give its consent to the ongoing legal battle that is taking place between Ripple Labs and the United States Securities and Exchange Commission. Regarding how the Post disclosed that there was a substantial development in the case, the Post provided the impression that Ripple had released 500 million XRP from escrow, which indicated the potential of a settlement arrangement worth $300 million. The first amount that the Securities and Exchange Commission asked during the investigation is a small percentage of this number, which is a small portion of the total amount. On the 16th of April in the year 2024, the Securities and Exchange Commission is going to hold a final preliminary hearing conference, which is also referred to as a settlement conference. Preparations are now being made by Ripple to attend this conference. It is at a time when anticipation is increasing that this information is being provided. In the cryptocurrency community, there has been a great deal of speculation going on about the consequences of these recent developments. This is especially true because the Securities and Exchange Commission is rumored to have conducted a meeting behind closed doors to discuss the settlement with Ripple Labs. To disseminate this information, a tweet was sent out regarding the forthcoming closed meeting that would take place. The Securities and Exchange Commission is the first place to go. These kinds of incidences have a direct influence on the market attitude that surrounds XRP and other tokens that are related to it. Jack the Ripper, a well-known XRP influencer and analyst, did provide a hint about the gravity of the situation during his statement. A recent meeting that took place on April 11 and was held behind closed doors. The SEC is experts believe that Ripple and the SEC could reach an agreement on the institutional sales of XRP with reduced penalties, even though the issues were resolved after the SEC dropped charges against CEO Brad Darlinghouse and Executive Chairman Chris Larson. The deal also includes the pursuit of a final judgment against Ripple for discouragement and predicament, as well as civil fines totaling over $2 billion. Permanent injunctions are also included in the deal. The chief executive officer of Ripple, Brad Garlinghouse, and the chief legal officer, Stewart, both voiced their disapproval of the Securities and Exchange Commission, stating that they would expose the regulator in a file that was made on April 22. Meanwhile, the most recent meeting held by the SEC involved additional discussion about the possibility of a settlement, which has arisen as a result of Ripple's delayed XRP unlocks from escrow and Ashley Prosper's rationale that the litigations between Ripple and the SEC are likely to be terminated. UNP is making its deposit making available for public record, and a decision from the United States Court of Appeals for the Second Circuit is also being made available to the public at this time. The following is an examination of the endeavor that Bitcoin has undertaken in the past year that is considered to be the most ambitious. Through the use of convincing evidence, Coinbase was able to argue that transactions on the secondary market that use cryptocurrencies do not constitute transactions that are subject to security court scrutiny. In reaction to this, Tors concluded that persons who purchase XRP on the secondary market are just as much a part of the market as those who purchase it on the primary market. Was provided with new grounds for his decision regarding the sales of XRP on the secondary market as a result of this decision. Coinbase has filed an interlocutory appeal to the matter that was initially brought forward by the Securities and Exchange Commission. In its appeal, the company has asked the same court in the Second Circuit to provide clarification on the meaning of investment contracts. In addition, the appeal that was filed by the Securities and Exchange Commission in the XRP Gova case was rejected by the Second Circuit Court of Appeals, which prompted many individuals to assume that Ripple could be able to prevail in the case. Because this is a topic that is of great significance to our sector, we are urging that the appeal be submitted earlier than is customary. The proceedings initiated by the Securities and Exchange Commission, SEC, against Ripple and other companies that deal in digital assets go beyond the regulatory authority that is legally authorized. An unjust shadow is put on the development of digital assets in the United States, according to the chief legal officer of Paul Grell Coinbase, who indicated that the measure was passed by Congress and that it casts a shadow. An attorney who is in favor of XRP named Bill Morgan has suggested that if Coinbase is unsuccessful in its appeal, it may be possible for the Supreme Court of the United States to improve its position in the XRP programmatic sales case. The SEC is demanding clarification from the court over the investment contract phrase in the SEC complaint. The outcome of the appeal could influence the regulation of cryptocurrencies in the United States. Coinbase has asked for an urgent preliminary assessment of the investment contract about cryptocurrency transactions to hasten the resolution of a major legal dispute that is currently pending before the United States Securities and Exchange Commission. Additionally, the SEC has requested that the court clarify the phrase on the investment contract. The United States District Court for the Southern District of New York has been requested by the Bitcoin Exchange to provide clarification on a certain matter. Coinbase's chief legal officer is listed here. On April 12th, Mr. Paul Grau delivered a statement underscoring the importance of court direction in the matter of determining whether or not an investment contract can still be evaluated by United States law. Although the Securities and Exchange Commission has concluded that such elements are not required for a contract to be called an investment contract. We at Coinbase believe that an investment contract must include something contractual to be considered an investment contract. However, the SEC disagrees with this view. Today, Coinbase submitted a brief to the court requesting permission to seek an interlocutory appeal in our stroke case. The brief argued that these requirements are extremely important. The decision to appeal the court's decision to dismiss the case against Coinbase was made shortly after the court rejected the relevant agency's motion to do so. The relevant agency has filed a charge against the exchange, accusing it of acting as an unlicensed exchange broker and clearing agency. If the court accepts the appeal, it could change the outcome of the case, potentially leading to the settlement of large claims against Coinbase. This interpretation of the law is based on the fact that the Coinbase case was dismissed. This legal issue may also have an impact on the Bitcoin business in the United States as a whole. The importance of stress, given the haste with which Coinbase filed its appeal just 17 days after the dismissal petition was denied, and the potential impact of the decision on the development of digital assets in the United States, it is evident that the company is committed to finding a solution to this problem as quickly as possible. Coinbase's appeal to the United States Court of Appeals for the Second Circuit, which was granted on April 6, upheld the company's authority to sell cryptocurrencies on the secondary market through its platform without violating the Securities Exchange Act. The appeal was successful. The legal action that was taken came about not long after the company's appeal, which was ultimately successful. Given the greater regulatory problems that Coinbase was facing, the ruling was a significant triumph for the company. A native lending mechanism for the XRP ledger has been announced by Rolex, according to the announcement that was issued. The objective of this protocol is to alleviate the difficulties associated with direct lending and to enhance decentralized finance